of the Short Circuit podcast. Instead of discussing cases, we will be talking to a brilliant young scholar who has an upcoming article in California Law Review arguing for a realignment of Section 1983 with its roots as a strict liability statutory tort. This paper could not be more timely. These days, our TV screens are dominated by images of ICE raids with unconstitutional conduct unfolding in front of our own eyes. As victims of these raids bring to light the extent of mistreatment, we often ask ourselves whether it makes sense to hold individual ICE agents accountable, given that they seem to act in accordance with the duties assigned to them by policymakers. But as Matteo Godi explains in his article, focusing on duties instead of the harm caused violates the original design of the civil rights statute that's the main mechanism for bringing claims by victims of constitutional violation. If that's true, and courts realign their jurisprudence along the lines of Matteo's research, it will be a new dawn for those who suffer at the hands of government officials, at least on the state and local level. Federal officials are excluded from Section 1983, which is something we will also touch on briefly in our conversation. Before we dig in, let me tell you about Matteo and his accomplishments. Matteo is an assistant professor of law at the University of Southern California, where he teaches a first-year lecture on torts and a seminar on statutory torts. Prior to USC, Matteo practiced appellate litigation at Paul Weiss and taught courses on tort law at Yale Law School. Matteo clerked for Guido Calabresi on the Second Circuit and also for Ketanji Brown Jackson when she was a judge on the United States District Court for the District of Columbia. Matteo first came to the United States from Italy as a high school exchange student in Boise, Idaho. He eventually came back to get his BA and law degrees at Yale. Matteo is the first member of his family to attend college. Welcome, Matteo.
Thank you so much, Anya. It's great to be here, and I'm excited to talk about my paper, though I guess all law professors are excited to talk about what they think.
Not only law professors, believe me. So your paper begins by questioning the fundamental assumptions that we take for granted about 1983. So what are these assumptions, and why did you want to point them out?
Sure. So let me start from the second question. Why did I want to point these out? In law school, we're taught to think of torts as a common law subject. It's a matter of state law. You have, as my students know, majority, minority rules. You have states doing one thing, states doing the other, and that's the gist of 1L torts. And then we kind of forget about tort law until graduation for the most part. But after graduating, I began to realize that tort principles were coming up all the time, and especially in the context of statutory causes of action, and especially in federal courts. And so I was a little surprised to realize that, and I was also surprised to see that no one was really writing about these statutory torts as a subset of tort law. So I started to write a paper during one of my clerkships. I guess that was a while ago at this point, like 6 or 7 years. And that was on Section 1983, just because it was a statute that courts routinely say sounds in tort, whatever that really means in practice, and we can put a pin there. But I picked up that paper, many times trying to figure out what was the problem with 1983, and it eventually expanded into a broader paper about statutory torts generally beyond 1983, Title VII, FDCA, FILA, et cetera, et cetera. And while I was teaching a seminar on statutory torts, it's when it all finally clicked, and when I started to realize that the problem with qualified immunity and the problem with all of these state of mind requirements and why they didn't really seem to make sense was because they were sort of all made up from the perspective of tort law. They don't fit with basic principles of tort law. And so I narrowed the paper again back to 1983, and that is where we are now. So to your question of what is the basic premise here, I hope you bear with me for a second. I may take you back to 1L tort law, but if you think about one of the basic distinctions in torts is between negligence and strict liability, between what we may view as a conduct-based tort and a harm-based tort. So when you think about negligence, it's the breach of a duty of care. You have liability because the defendant's conduct is substandard in some way and causes damages to another person. And so you impose liability as a court because of that defective conduct. And vice versa, if the actor causes some damage, but their conduct is reasonable, they acted with due care, we do not have liability. Conduct and substandard conduct in particular is what triggers liability. But strict liability works in a fundamentally different way. We don't impose liability on blasters of dynamite, for example, only when their conduct is not careful or not reasonable, when they fail to act in a certain way. If they cause harm, they are liable. The conduct can be entirely okay. It can be beneficial to society or to the plaintiff, but even if they're super duper careful, you still impose liability. And we can do the same, with trespass. We're neighbors, assume we were neighbors. We have some trees on the boundary line of our properties. You think they have some bug infestation, they need to be trimmed. I don't, but you think they're on your side of the property, you go ahead and trim them without asking me. Well, if you do step on my property, that is going to be trespass. Doesn't matter that you were careful, that you were reasonable in thinking it was your property. You're still going to be responsible because the law is drawing a line around my property. And if you cross that line, you deprive me of my property right and you're liable. So at bottom, strict liability is about whether the defendant did the physical act that damaged the plaintiff. And if the answer is yes, you did the thing and you caused damages, you have liability. And my argument in this paper is that Section 1983 is written to work precisely in that way.
And so before we go kind of into 1983, why is it that tort law draws that distinction? Why is it important on the one hand to look at conduct when it comes to negligent tort, for example, and on the other hand to have this strict liability tort where all that matters is the harm that was suffered by an individual?
It goes to the question of what is that tort rule supposed to do. At bottom, tort law is going to be about shifting the cost of a particular conduct from one party to the other. And the question is, what is the rule of liability to do that? Do we want to shift the cost categorically whenever a harm takes place, whenever an impermissible right deprivation takes place? Or do we want to do it only sometimes when we think that, as a famous judge said, for the convenience of humankind, we want to put up with some mischiefs, the ones that reasonable care cannot avoid. So do we want to do it categorically, or do we want to do it just in certain circumstances where we cannot avoid those accidents through reasonable care? And tort law sometimes draws the line at it's only a question of reasonable care, or it's only a question of intent, and other times it draws the line at the activity level, at we want to impose liability because this course of conduct causes harm, causes an infliction of deprivation of a right. And so those are, it's not that they're incompatible, they're just entirely different frameworks of liability, and the principles of one will not necessarily translate and be importable into the other.
Right. And it's so interesting because, yes, when we think about qualified immunity cases, for example, in modern jurisprudence, they're very much soaked in this language of reasonableness and cost and benefit analysis, and what kind of a rule should we create to encourage, officials to act reasonably. It really seems to have very much that language of the conduct-based tort, rather than a focus on, what was done and whether the law was violated, and whether the conduct caused the harm, and then kind of looking specifically at that harm.
That's exactly right. That's why my paper argues that version of qualified immunity is just incompatible with strict liability, but so are the state of mind requirements, and we can talk more about that. But
yeah.
I think the fundamental problem with qualified immunity is exactly the one you pointed out. You have a doctrine that is created around the assumption that it matters whether the state official is acting reasonably, whether the right is clearly established, because reasonable officers are presumed to know clearly established rights. And so the failure to know that right is evidence of some unreasonable conduct. But that doesn't matter. Like, it's entirely irrelevant. We don't ask whether you, as my neighbor, knew that it was my property. You can think it's your property. You can think you're entirely within your rights to cross that boundary line. But if you do take that step and you intend to take that step, that's all that matters. You can be wrong. You can be mistaken. The law is not faulting you for that mistake. It's just saying you're going to be liable for the damages you cause. And we see that in tort law all the time. And it's one of the problems with this language of fault that comes up in tort law, but a lot in 1983 too. We associate a lot of torts with fault, with this moral component of the inquiry, where in reality, a lot of tort law is not trying to determine who's at fault. We don't think if you're incapable of acting like the reasonable person would under the circumstances, you're morally reprehensible, but we still hold you liable if you fail to act like the reasonable person. You may be intrinsically unable to do so. There are famous cases that you read in 1L tort law where the defense is, well, I did my best. I was just unable to live up to that standard, that objective standard. And so you shouldn't impose a liability on me. And courts all the time say that doesn't matter. It's not a moral judgment. It's just the subjective standard. And so even with negligence, where really that's happening, we still have this language of fault that comes in, and you see it bleeding into strict liability and Section 1983 to the point that all of a sudden it morphs from, this even objective inquiry that you see in negligence and maybe with qualified immunity into really a more subjective inquiry into fault and state of minds that we see more generally with the rights that 1983 is used to enforce.
Yeah, let's talk about kind of 1983's enactment and kind of what is it that makes you say that it is a strict liability tort?
So, I mean, if you go, we don't need to spend a ton of time on the whole history. There was, hundreds of pages that have been written and hundreds of pages of congressional records on it. But the gist of it is you had a problem, a campaign of terror by the KKK that prevented people, and Black people in particular, from exercising their rights in much of the South. And state officials were entirely complicit with that. They were turning away. They were not prosecuting those crimes. They were not. The judges were scared or unwilling to enforce these laws at the federal level. And so you have a problem. Congress has a problem. What can we do to make sure that constitutional rights and federal rights more generally are not taken away from individuals in certain states? And the answer was, well, we're going to interpose the federal government between the states and the people. We're going to put the federal government into the picture. And you have various efforts to do that, various, criminal laws, various administrative bodies that are created, constitutional amendments. But all of those collectivist approaches where you have the government driving the analysis and the decision over whether or not to enforce a right were not deemed to be sufficient. And I mean, that's fundamentally the role of tort law, right? Like we still have criminal law. We still punish certain conduct. Sometimes crimes are torts, but we still have both. We allow both because they serve different goals. And so the Civil Rights Act of 1871 creates this private right of action that opens the doors of federal court to injured citizens through this new tort that is premised on a mistrust of state officials. And so rather than putting the burden on officials to initiate these claims, it allows individuals to enforce their rights by leveraging these private mechanisms of enforcement to pursue what may be otherwise viewed as public goals. And I argue that that was a deliberate choice. It's not that one approach, that criminal law, that a collectivist mindset to a problem is the only way to go, and we rarely think that's right. You also have this individualistic or private enforcement-driven mechanism. And Congress adopted that. I think that's what 1983 is doing, not instead of, but in addition to what the other Reconstruction era reforms were meant to do.
And so why is it that Congress thinks about it as a strict liability tort instead of, let's just allow them to come to court and prove that they acted, unreasonably? Like, why is it that what Congress is choosing is a state, like a strict liability cause of action?
Yeah, I mean, I'm a big believer that, statutes are addressing problems. So the question is, what is the mischief? What is the problem that Congress was trying to fix? And it seems that, yes, there was a problem of invidious, intentional discrimination in a lot of the South. But that was not the end of the story, right? It was a system that was created either to intentionally or by inertia deprive individuals of rights. And so if you allowed an individual state official to say, well, I didn't do it with malice, I'm just enforcing state law, well, that was a big problem in the early cases. That was the line of defense that a lot of these officials invoked. Well, I just followed state law. I didn't mean to do this. I didn't mean to deprive them of their constitutional rights. I was just following the law. I wasn't acting woefully. And the courts tell us, well, that's irrelevant because, again, the problem that Congress is trying to address is not the defective conduct on the part of some states, the substandard conduct that some officials are engaging in, but the deprivation of rights. And rights are taken away whether you do it intentionally, maliciously, or simply pursuant to state law. And so that's really the fundamental problem that 1983 is trying to resolve, and to make it instead an inquiry into whether someone acted with the right intent or whether they acted unreasonably is sort of flipping the whole statute on its head.
So in a way, when they say, like, if you acted under color of law, it's kind of very much the context to it is, even if you are acting pursuant to duties and with good intentions, whatever it is, that's not what we care about. What we care about is the harm to the individual.
Exactly. I mean, you have a lot of these early cases where some of the debate was around what it means to act under color of state law. Well, can you act in violation of state law? Well, if your authority comes from state law, you still may be acting under color of state law, regardless. And the same is true where you are in fact enforcing a state law.
Yeah, that I think is a very important move to make. Why is it that federal officials were not part of Section 1983? And I think for many, the answer will be obvious. But what essentially are the repercussions then of federal officials being excluded from Section 1983?
Yeah, I mean, look, this was, a statute passed in 1871. The problem at that time was not that federal officials were not willing to enforce the 14th Amendment, the 15th Amendment, federal law. That was not the issue. The problem was state officials and state actors that were, despite the existence of federal law, still depriving individuals of their rights under federal law. And so the problem that Congress was trying to address is really this deprivation by state officials of rights recognized under federal law. The problem at that time was not federal officials. And so I think the explanation for why federal officials are not within 1983 is the simple fact that it's coming out of Reconstruction, where the problem was very different. Now, we could have a whole conversation about whether we should have a 1983 equivalent for federal officials, and that is what Bivens was trying to do. Of course, not in the context of a statutory tort, but really what I would view as a true constitutional tort, a common law cause of action.
Yeah, and it's just so interesting that today we kind of use Section 1983 as the main mechanism to obtain remedies for violations of constitutional rights. And because federal officials are excluded from it, not through, any particular, good reason other than the context at the time, now we can, we see ICE agents, committing all kinds of violations. But if they were state officials, we would be able to use Section 1983, however flawed it is today. But because they're federal officials, there is essentially a huge remedial gap where you can't really sue them for violations of constitutional rights.
Right, and that remedial gap was not always been there, right? It's sort of the way in which the court has evolved the Bivens cause of action to mean that it only applies to individuals named Bivens and no one else, effectively. Right. But that is not the necessary consequence of the creation of this implied right of action under the Constitution. But it's one that is harder to attack on the terms that I am attacking the way the Section 1983 jurisprudence has evolved, because of course, and that's why my paper kind of doesn't go into Bivens.
Yeah.
It's because my critique of 1983 is very much informed by the fact that it's a statutory tort, the fact that it's a statute that had a purpose, that has certain language that crystallizes certain elements and takes it away from the courts to rewrite those elements in a way that instead, theoretically courts could over time try to undo what negligence means through common law decision making and changing the fundamental requirements of that common law cause of action. It require a lot of overruling precedent and all of that, but it's something the courts are equipped to do. But here you have this separation of powers issue kind of lurking in the background too.
Yeah, it's very interesting how you talk about in the paper of kind of like the misservice or the disservice of calling 1983 a constitutional tort statute, right? That you kind of urging people to like move away from calling this a constitutional tort. So maybe just spend a second to kind of zoom in on that particular phraseology.
Sure. I don't have, anything against the phrase constitutional tort per se. I think that it's actually very accurate and very apt for Bivens, for example. It's a cause of action for constitutional rights created under the Constitution, and so it is a constitutional tort. But when you talk about 1983 as a constitutional tort, you're I think unduly overemphasizing the constitutional aspect of it over the tort aspect of it. Even putting to one side the fact that, 1983 is not just about constitutional rights, it's also about rights under federal statute. So, but let's bracket that. Even when you bracket that, the fundamental problem is that the constitutional tort framework is justifying and fueling the shift to look at the Constitution, at constitutional norms and principles as the primary source of the elements of this tort, of the limits, of the defenses, where in reality, because it's a statutory tort cause of action, the first place to look is the text. What does it say? What are the elements? what is this tort about? And instead, it seems to be the text and its history are the first thing that courts are willing to put to one side, oddly enough, in these days. And they say, well, of course it cannot mean what it says. Of course we cannot apply it in that way. Well, like, why? And they say, well, because you have all these it's a constitutional tort. You have all these constitutional norms and constitutional principles, and you need these state of mind requirements under the Constitution to enforce federalism principles and so on and so forth. But that's already assuming that all of those principles are relevant and that, in fact, state of mind requirements are part of the inquiry under the statutory cause of action. I spend a lot of time in the paper trying to draw this line between what is a right and what is a duty, and these state of mind requirements and qualified immunity are really going at duties rather than rights, and sometimes they are one and the same, but many times they're not.
So yeah, let's put some meat on the bone in that situation. So let's imagine, like one of the most common 1983 claims and how it would work under your framework and how it works now, right? Like, let's talk about excessive force violations by police officers. How should it be analyzed consistent with the framework that you propose versus how is that analyzed right now?
Sure. So my framework is, again, asking whether there was an impermissible harm that caused damages. That's it. That's a strict liability tort. And so did the officer perform the act that deprived the plaintiff of a right with injury and causation as the other elements that are required? But it's the deprivation of the right itself, the impermissible harm, the act that triggers liability. And my article is rejecting the idea that the state of mind or reasonableness of the conduct that leads to that action is the trigger for liability instead. And so it doesn't matter whether an officer is acting with objective reasonableness in violation of the Fourth Amendment. You just focus on their act and whether or not they deprive the individual of a right under federal law. So, you ask, did they intend? At most, I think you can ask, did they intend to do the thing that amounts to a right deprivation? And so that is one of the concessions that I make in the paper, and that is you might need the act to be intentional rather than volitional. That is not itself incompatible with strict liability. So, for example, for trespass, you do need to take that intentional step. It's not just that you can be pushed onto somebody's front lawn and that is a trespass. It was an accident. But that's not that big of a hurdle for the classic excessive force case, I think, because you would just ask, was there an intent to make the contact that caused the deprivation of the right? And that would suffice for liability, even if there was no intent to cause the particular injury, where there was no intent to harm, which we see in malice, which we see in the Eighth Amendment context, but also regardless of whether there was any objective unreasonableness on the officer's part, which is what we're seeing in a lot of Fourth Amendment cases.
Yeah, and so the way that the courts are looking at it now is very different. So can you just briefly talk about that so our listeners can kind of see the contrast?
Yeah, so instead, right now, in the Fourth Amendment context, for example, objective reasonableness is a big part of the picture. And so you ask whether it was objectively reasonable for the officer to do what they did. And you only attach liability where the conduct of the officer is falling below the standard that the courts have set, the subjective reasonableness standard, which is very different from asking instead whether or not, regardless of whether the officer was acting objectively reasonably or not, if they instead did the thing that the plaintiff is claiming caused them harm. If they did, under my reading of Section 1983, that is all that is needed on that first element to trigger liability. And then if you have causation and damages, you are set. In the current scenario, instead, it's not enough to say the officer did the thing that caused you the deprivation of a right under federal law. You also need that what they did fell below some objective standard of reasonableness. And only if it falls below that standard of reasonableness, then, well, assuming you can survive a qualified immunity defense, which brings in more fault-like reasonableness type elements. But if you meet that objective reasonableness hurdle, if you meet that qualified immunity reasonableness-like defense, then you could recover damages.
And that really gets us to this, part of your paper where you address counter-arguments. And sort of a lot of people would basically say that if you don't do this duty fault analysis, then, it gets everything out of whack. It's kind of what courts are very much comfortable looking at, and the incentives that it would create in terms of the kind of behavior that they want government officials to perform. So what is your response to just like the basic objections to your theory, which basically is that I don't care whether, that the focus essentially is on the harm and not on whether the officer, violated duty.
Yeah, so I mean, the fundamental pushback there is, well, there are these due process-like, federalism-like concerns that justify the limitation on liability, because otherwise liability without fault would be unfair to official. It would intrude on state governments' responsibilities. It would over-deter. And then it would create incentives for courts to start maybe limiting rights so that liability is not so sweeping. But I think that all of that that family of concerns is largely overstated. I mean, even once we put to aside the fact that Congress considered objections to Section 1983 strict liability in its debates and still went ahead with the same strict liability language. But once we look at practice, awards are paid by employers, not by the individual officers or by insurers. Insurance could, maybe you even require insurance, and all of a sudden the incentives are not so much in favor of caution on the individual officers because they're not individually liable. But you also have other ways that liability could be less than this unlimited liability when you look at tort law on its own terms, right? Like, just because it's strict liability, it doesn't mean that you don't need causation. It doesn't mean that you don't need proximate cause. It doesn't mean that you don't look at other common law limits that my students are hearing about these days, foreseeability, scope of harm, and all of that. So there are other constraints.
Apologies to all one else out there.
But regardless of, let's put tort law and those principles to one side, so the fear is strict liability, too much liability. And so courts will just narrow the constitutional rights. And I think that the fundamental problem with that critique is that it's assuming that liability is created by 1983. There isn't liability but for 1983. And of course, that's false. There is liability when a harm happens. Somebody's going to bear that cost. And tort law and 1983 are only telling us who is going to bear that cost, not whether liability is created out of thin air. And so 1983 is telling us categorically, we, Congress, want state officers to bear the cost of deprivations of rights under federal law. We never want citizens to bear those costs. And so I sort of disagree with the general push on too much liability, but I'm willing to take it for granted. Say, sure, that's right. Like there'll be more liability, and then what? Well, I think then the question is, which world do we think is better? As I argue in the paper, I don't know that the world where rights are narrower but protected by a strict liability rule is worse than the world we live in today, which is a world where rights are perhaps more broadly defined, though, of course, query whether courts even define them because of how the qualified immunity inquiry works, where they just skip over the question of defining the right and just go straight into the reasonableness part of it. But sure, you have rights that are more broadly defined, but then you have these state of mind requirements and qualified immunity limits that come into the picture and make it so that even someone that is right at the core of that right, that whose deprivation is really, really at the core of what the Fourth Amendment is all about, still may be unable to recover because they're unable to show objective unreasonableness or whether or overcome qualified immunity. And in a strict liability world, instead, you're right at the core of the right. You do get to recover damages that were caused by that act.
Yeah, that's a very interesting thought. Like, what is the world that we want to live in, where we have a lot of rights on paper, but they're not enforced, versus, well-defined, limited rights that are necessary for the, thriving of the individual, essentially, and that are strictly enforced.
Right.
So, and what about this idea, and there is some scholarship coming out on this now, that Section 1983 is not a cause of action in the first place?
Sure. So I think the gist of the argument is what you suggested, with a couple of additions. So the argument is Section 1983 did not create a federal cause of action at the time it was enacted. It simply gives jurisdiction to enforce common law, state law causes of action. And that is because it says that state actors are liable in any action at law or sued in equity. That's the language of the statute. And it doesn't pick one or the other. Congress did not choose a form of action as they were called at the time, nor did it create some other one other than, suits at law or in equity. And so there's no cause of action here. That's sort of the argument as of 1871. I think there are several problems with that argument. First, to me, it's not clear why Congress needed to pick a single form of action, and why the fact that it didn't pick a single form of action is somehow evidence that it didn't crystallize one or multiple in the statute. The plainest explanation for that ambivalence, I think, again, goes back to tort law. Actions in law and suits in equity were okay for trespass, for example. And Section 1983 is recognizing it, I think, a new trespassory tort, one that protects rights and says that deprivations of those rights are capable of giving rise to either legal or equitable remedies. So the fact that it didn't pick one is simply because of the kind of tort that it crystallized in federal law, not because it didn't mean to crystallize any cause of action at all. But then I think that the historical claim that Section 1983 was not understood to create a federal cause of action is both questionable on its own premises and likely immaterial today. So if you look at, there's as far back as 1885, like 10 years or so after the enactment of 1983, you have Supreme Court cases that ask whether the plaintiff has a quote-unquote cause of action under Section 1983, not by looking at whether or not they have a state law cause of action, but by looking at the statute. They say that's a question of whether the plaintiff, within the meaning of the statute, was subject to a deprivation of federal rights. And anyway, even if we look at modern doctrine, where the federal rules of civil procedure tell us that there's only one form of action, the civil cause of action, the civil action, then the question as for whether or not 1983 creates a cause of action is really whether the statute displays an intent to create both a private right and a private remedy. That's what the Supreme Court has told us the test for determining the existence of a cause of action is. And of course, 1983 plainly does both. It does create a set of private rights. It recognizes these rights under federal law, and then it creates a private remedy. It says you can sue for them in federal court and seek damages or equitable relief.
Yeah, and as we wrap up our recording today, I kind of want to go back to this split that you identify of fault-based versus strict liability, and how this assumption that it is fault-based kind of created a whole bunch of problems for courts, including in how they analyze qualified immunity, right? We see a lot of confusion in this two-part framework, where it begins with, was the right violated, and then was that right clearly established? What we see a lot with courts is that they kind of substitute the question, and instead of asking was the right violated, they're asking was a duty violated, essentially. And if the duty wasn't violated, then they assume that the right wasn't violated either. And kind of, a couple of months ago, a very conservative judge, actually, Andrew Oldham, wrote a concurrence, and we'll post it in our notes, in Villarreal case, like an nth iteration of it, where he very much talked about at issue is whether a journalist's First Amendment rights were violated when she was basically put in jail, right? And a lot of judges, when they're looking at this question, they're kind of looking at prong one of qualified immunity, whether the right was violated. They're kind of looking at whether or not there was probable cause for her arrest. So in a way, they're kind of looking at whether or not an officer properly performed the arrest. And what Andy Oldham is saying is that that's a wrong way to look at this question. You should really look at, is there a First Amendment right to not be thrown in jail after you criticize the government, or something to that extent? So do you think that's a way to somewhat address your problem, or at least a step in the right direction? And why isn't it like a perfect solution for you?
Yeah, so I think you're right. I we've been emailing about this concurrence. I don't know that I have incredibly well-formed thoughts, but I think I generally agree that it's a step in the right direction, as in it's starting to recognize some daylight between these fault-like, culpability-driven requirements and the right itself. And so I think that it's promising that some judges are starting to question, well, are these part of the right? Are these duties? Are these considerations of reasonableness or malice, of intent to harm, of what have you, part of the right itself, or are they external to it? And I think that Judge Oldham is doing that, though I think that, he still is operating, and that's, where I would still find flaws in his reasoning. He's still operating under the framework of, well, it still matters whether the right is clearly established, again, on the theory that reasonable officers know of clearly established right. And so sure, he's quibbling with what is the right, and he's starting to recognize that there are things that we do take into account when we resolve these cases that are in fact not part of the right, like probable cause. But then he's still going back to this reasonableness type analysis that qualified immunity gets us into. And that is, of course, the whole problem with the way in which courts are reading Section 1983 today, in my view, is that they're departing from this strict liability regime where the only question is whether the defendant did the thing that deprived the plaintiff of a right, and instead they focus on the officer's state of mind or the reasonableness of their conduct. But at least he's starting to cabin some considerations that are now treated as part of this inquiry into whether or not a duty was violated, and instead saying, well, those are not about the right, and Section 1983 is about rights, not about duties.
Well, these are early days, Matteo. You are in the beginning of your academic career. I look forward to us getting together, maybe 10 years from now, 20 years from now, where we can actually look back at this paper and say that this is when it all started to change for the better.
That's quite a positive outlook on the state of the world. I don't know that I am as positive as you, but I think even incremental, as I mentioned in the paper, even if we can go back to the ideal correct way of reading Section 1983, I think we can make steps in the right direction. And I think that even baby steps are going to go a long way in what is otherwise an incredibly messy and honestly hard to understand area of the law.
It all has to start somewhere. Thank you so much for spending your time with us today and talking about this wonderful paper. And I hope that, we don't have to wait 10 years to actually talk about another paper that you will write. I'm just saying that this paper we're going to reassess coming up. So I'm hoping that we can have you on again soon to talk about your scholarship, or maybe on our more of a traditional format episode where we can talk about lower court cases and what judges did right and didn't do right.
I would love to. This was a lot of fun, and thank you so much for having me. I look forward to the next time.